Everyone, thank you for joining us for the J&J Consulting Services investor call this afternoon. My name is Jeff Winkler. Most of you know I'm the court-appointed receiver in the Securities and Exchange Commission versus J&J Consulting Services, Inc. case. I wanted to have an opportunity to give everyone an update on the case like we do, like we like to do every quarter, let you guys know what is going on and what we're working on and what the next steps will be. So quickly, a disclaimer. Anything I say in this call should not be construed as legal or accounting advice, as I am not your attorney and not your accountant, so I'm not allowed to give you any advice in the capacity. However, I am here to provide you some information about the receivership and help you understand what it is that we're doing here. Another reminder that any party mentioned in this case is innocent until proven guilty in a court of law. And so nothing should be construed to say that I am saying that somebody's guilty of doing anything in this case other than what has been adjudicated by a court. So quickly, we've gone through what a receivership is. I am a fiduciary. I'm a neutral third party. It's my job to manage the assets of the state and to make decisions on litigation and other things for the benefit of all the investors in this case. And we take that job very, very seriously. We are constantly looking for ways to find additional assets, looking at potential litigation in order to try to recover additional funds, and then also watching, what we spend and how we spend it, based on a cost-benefit analysis, making sure that anything we do benefits investors overall. We know that this process can be a time-consuming process, and people have a lot of questions about it. The number one question we always get asked is, how long is this going to take? And unfortunately, that is one of the questions that's the toughest to answer. But realistically, this case will last somewhere between 3 and 5 years. It could be a little less, it could be a little bit more, but that is what is normal in these cases. But they are made up of a bunch of different, events that we do as we go throughout this process. The very first thing we were focused on was marshaling of assets, gathering the houses, the cars, the boats, the airplanes, things like that. While at the same time, we began our investigation and our forensic accounting. As a reminder, there was no single accounting for all the investor funds that were brought into this case. And so, unfortunately, we've had to do a forensic accounting from scratch, which means that we've had to subpoena bank statements, we've had to get copies of checks, wire transfers, other types of transactions. We are looking at, close to 300 bank accounts at this point that we are that we have subpoenaed, and we're looking at tens of thousands or hundreds of thousands of transactions that occurred in these accounts. And so we have to figure out what money came in from investors and what money went out to investors, as well as what other money may have come in and gone out for purchases of assets. We look at those to figure out if there's additional assets that we don't already know about that we can go after, as well as helping to identify the different parties involved. As we've mentioned a couple times, this case was made even more difficult because of the fact that investors invested in so many different ways using LLCs and other investment pools. And so that's why we had sent out that claimant questionnaire, our investor questionnaire earlier this year, so we could ask questions about how people invested, what the name of the entities were. Because one of the biggest disadvantages we're working with right now is we don't have a single list of every single person who invested in this case. And so when we see names that show up on bank statements, we have to figure out, is that an investor, or is that a contractor to one of the legitimate businesses that some of these funds went through, or was this an asset purchase? And so we have to go through and figure out what each individual things were. And so we've been working on building up this investor list. As you've seen, we put out information on the website. We send out emails to people. We have worked with a couple of the local newspapers to run stories about what it is we're doing, a couple of the national papers, just so we can try to make sure we have a good understanding of all the different investors involved in this case. That also included working with the FBI. They gave us a list of their investors they had gathered over time, as well as the list that the SEC had procured as well. And we've added those all together. Right now we're well over 1,000 investors, and we anticipate that number is probably going to get closer to 1,500 or 1,600 by the time we're done. Just to give you an idea of what it is. So, we're talking about, over $500 million that flowed through these 300 different bank accounts over a 5-year period of time. And so it's a pretty complex process. And, because this involves your money, we have to do it right. And so there are no shortcuts that can be taken. We need to make sure we understand every penny that every investor's owed and every penny that was spent, so we can make sure that the right parties are responsible for returning those funds, and that we're able to go after any assets connected to it. So as we've gone through this forensic accounting, and just to give you guys may have seen some of the filings in recent weeks. The SEC, I believe, has asked for an extension on the discovery deadline in order to give us time to finish our forensic accounting. And the reason why our forensic accounting is so important is it's not just a measure of how much money went in and how much money went out, but it's a measure of how much money went to every single person involved in this case. Because one of the next things that we will do once the forensic accounting is done is a claims process where investors such as yourselves are going to be able to make a claim on the estate for the money that they invested. And we need to make sure we know what that money is, because we have to come to an agreement on that in order to then ask the court to either approve that claim or deny that claim based on that information. And so we can't get it mostly right. We have to get it all right because it's your money. And it's important that we get it down to every penny. And that information, even though the primary use of it is for our claims process, it will be used in other areas, including litigation against third parties. For example, our lawsuit against Wells Fargo. In order to state an amount of damages that are owed, we need to know the difference between what investors put in and what investors got back, less any money that we have recovered. And that'll give us our damages number with the bank. That's also true of certain defendants, as well as other third parties, attorneys, accountants, and potentially other financial institutions that are that have not been publicly sued at this point. So that's why that process becomes so important, and why it is, that it's so important that we get it right. And unfortunately, because we've had to subpoena bank statements, some of those take months in order to get the information back from them. And then, of course, as we're going through these and we discover there's additional banks involved where money has been sent, we then have to subpoena those accounts to determine what that money's purpose was and how it was being used to ensure that we can trace it all the way, from all the way in and all the way back out again. So it is a big process and it does take a lot of work. But as I said, as we begin to wrap up the process of the forensic accounting, and that really happens in two stages. One, once we figured out the total amount in and out and the money that went to investors. And then after that, the second piece of that is we look at an investor by investor level to make sure that we understand every penny you put in and every penny you got out. Because when we begin the claims process, we are going to have a number that we think is going to be related to to your total investment in and out. And so we want to make sure that we can use that number for the claims process. So it actually serves a dual purpose there. The idea being that we don't want to have to ask investors to send us piles of paperwork proving how much money they put in. We don't need your bank statements. We don't want your wire transfers, all that information, because if we were to have to go look at that a second time, there's an additional cost with that associated with our review, as well as the cost associated with you getting those documents. And so our goal is to not to have to make you provide those documents to us, and for us to be able to do this in a much simpler, less expensive, and shorter manner. And so once the forensic accounting is done, we will begin the claims process, where we will then allow people, you generally have 90 days in which to file a claim. And then we'll go through that whole entire process. More information will come out as we get closer to that about what that looks like. So the goal now, and then of course, after the claims process wraps up, then we can pretty much immediately then begin the distribution process. We will end up doing multiple distributions in this case. So once the claims are approved and the courts approve the distribution plan, we will make an immediate payment out to investors at that point. And then as we collect additional money, let's say we settle with Wells Fargo, or we end up litigating that and we get an award from Wells Fargo, that money would then be distributed out. And so there will be multiple distributions as we go throughout the case, as we gather, chunks of money that are large enough to justify doing a distribution out of. So based on that, I want to then just kind of move forward with some of the questions that we've received over the last few weeks. We always want to hear from investors because we want to know what concerns you have and try to answer any questions you guys have. Of course, if we don't answer a question that you have, you are welcome to reach out to us via phone or email, and I'll provide that information at the end of the call. So first question, who has gone to jail or prison so far? So as of right now, there's only one person who is in jail, and that is Matt Beasley. He has been charged by the U.S. Attorney's Office with securities fraud and other similar charges. And so he is there pending the outcome of the case. There was a hearing held as to whether or not he would be released from jail a few months ago, and the court decided that they wanted to keep him there in the jail. What is this status of Matt Beasley and Jeff Judd? So Matt Beasley is in prison, but he has been cooperating. I've been talking with him or his counsel every few weeks. Anytime we have specific questions, we're able to reach out, and he's been very forthcoming with us on the vast majority of things, and actually has been assisting us in helping to make sense of what happened in this case. Jeff Judd is not in prison currently, but he also has been very helpful. He's been cooperative with us on turning over assets and answering specific questions related to things that are going on in the case. Next category of questions has to do with litigations. Can you explain more about the Wells Fargo litigation or the lawsuit with Wells Fargo, and do you anticipate a large sum of money there? So the lawsuit with Wells Fargo, so as you guys are probably aware, there was a class action lawsuit that was filed by a group of investors against Wells Fargo prior to the starting of the SEC case. I have since also filed a case against Wells Fargo alleging much of the same things, with the addition of a couple claims that are reserved for the receivership. Since technically I step into the shoes of the receivership entities, I can sue for things such as breach of fiduciary duty and some of these other types of claims that investors would not have individually, but we have because we become the client. And so we have sued Wells Fargo. And so the question is there going to be a large sum of money? The goal is obviously yes, that we do believe that there is a large settlement to be had there. We do believe that settlement will end up in 9 figures. But what that number ultimately ends up being is going to be based largely on the total amount of loss of investors, which is, again, why the forensic accounting becomes so important. In order for us to get Wells Fargo, assuming that, they accept liability or the liability is found by a court, then the question becomes, okay, what was the harm to investors? And so that's why the forensic accounting becomes so important, because they're not going to pay us based on some hypothetical number that we think it is. They're going to want to see, how every penny went in and every penny that went out in order to write a check in order for those losses. And so that's why that becomes so critical as well. What is being asked for Wells Fargo? So Wells Fargo, our statement of claim just says that it's in excess of $100 million. That final number will be determined as the forensic accounting gets wrapped up. During the last meeting, we were told that Wells Fargo was sued for a little over $200 million. I'm curious why they were not sued for the entire $500 million. We have not established a number that we are suing Wells Fargo for. Again, that number is going to be based on the net loss to investors. So they are going to be, we believe that Wells Fargo is responsible for the harm to investors, which is typically defined in legal terms as the amount of investor money that came in minus the amount of investor money that went out, minus any money that we have collected for the benefit of investors. And that will be what would be considered the loss. And that will ultimately be the number that we go after Wells Fargo for. What is the latest update on the Wells Fargo lawsuit? When can we expect to receive money from that case? So with the Wells Fargo lawsuit, we are in the process of doing depositions currently, which means that we are meeting with certain parties and asking questions. We have to date done a couple depositions of some of the plaintiffs in the class, and then depositions of a couple employees of Wells Fargo. We've gotten some good information from those depositions and continue to strengthen our case against Wells Fargo. What connection, if any, does the receivership have with the current court cases regarding the defendants, the individuals in Wells Fargo's? So with the stay that's put in place as part of the SEC case, investors are prohibited from suing defendants in this case, as well as, we believe that it also prohibits people from suing other third parties as related to this case. So anytime we see those, we will reach out and seek to get those lawsuits stayed or dropped, because it's important that, if all the investors involved in this case individually went out and sued all the defendants, you would have a huge mess of all these different people in court, and they're fighting for their own personal benefit. And so instead, what the court does is say, okay, nobody but the receiver can sue, because the receiver is in a position to sue for the benefit of all the investors in the case, and that money will then be distributed out to those investors on a pro rata basis based on your claim. And so that prevents any kind of races to the courthouse, multiple litigation. We don't want to be paying 30 different groups of attorneys in order to do the same litigation. So now what we've done, we've consolidated this. Our lawsuit, as well as the class action lawsuit, has now been consolidated, meaning that they are going to be, they're going to proceed together. So we're doing one set of depositions, we're doing one set of discovery in order to simplify the process. So we're not, so there's not 2 sets of charges that are going to be associated with this, as well as when the case is ultimately decided and the attorneys are paid out, based on their contingency fee agreement. One, we capped the agreement at 25%, which is significantly lower than usual. Usually contingency is somewhere between 33 and 40%. So we got a discount up front from it, and all the attorneys involved in the case, including the attorneys that represent me and the attorneys that represent the plaintiffs in the class, are all splitting that fee, and they're not each getting paid out those percentages. And we do that again to protect investor money. We want to make sure that it is as clean as possible, as inexpensive as possible, and as efficient as possible. We want to minimize the amount of time that these things take. Typically, litigation against a financial institution, if it settles, will usually settle in the first year or two. If it goes to trial, it can oftentimes be 3 or 4 years. We believe we have a case that Wells Fargo is going to want to settle. And so we're continuing to push for that. And that push will really, take full force, towards the end of this year, very beginning of next year, when the forensic accounting has reached at least its preliminary conclusions as to the amount of money that's owed. And then we can then begin some, fruitful negotiations in order to try to settle it short of going to trial. The contingency fee is based on the level at which the case is decided. So if we do it short of trial, the contingency fee will be lower. So we're always going to push to try to get it settled as quickly as possible. But of course, the maximum amount of money too. So we want to balance it with time, money, and expenses. So we are always looking at that, doing a cost benefit analysis on how the money is being spent and what it's going to cost to take the next step. So we can find the perfect place to try to get this settled. How long will the lawsuit take? I think I answered that. It's going to take somewhere between 1 year and 3 years, I would guess. Hopefully on the shorter end of that, because we want to try to get it done as quickly as possible. And so we're going to continue to focus on what that right number is and how we can get that settled. If Wells Fargo is held accountable, now that my lawyers dropped me, how that case be handled going forward. You don't have to be represented by an attorney in order to get anything out of the receivership estate or any of this litigation. The funds of the litigation, whether it is assigned to the class or to the receiver, is all going to be paid to the receiver. So all that money is going to be available for distribution to the approved claimants of the case. If Wells Fargo agrees to settle a lawsuit for a certain amount of money, will those funds be distributed through the receivership based on the claims filed, or will another party administer the funds? Again, like I just said, those funds will be administered through the receivership estate and will go directly to investors who have approved claims. Okay, assets. So the first question is, where is this money being collected, being held? So the money goes into special accounts that are designated as a qualified settlement fund, which is an IRS provision for any types of funds that are paid out to investors based on these SEC cases. The bank that they're being held at is East West Bank, which is a very strong bank, and it does not give us any concerns about their liquidity. In addition, the money that is in the bank is insured and is also drawing interest as well. Let's see. Second question, is the money being held collecting interest? If so, who is collecting the interest? So the interest is being collected on the accounts. The interest compounds in the account, and that interest will be distributed back out to investors as part of their pro rata claims in the distribution process. Number 3, is it correct that Paula Beasley is wasting investor funds? If so, what is being done to protect the funds? I don't have any evidence that Paula Beasley has wasted investor funds. We do have some questions about where some money went related to the sale of some assets. That is currently in front of the judge in our court, where we've asked her to rule in our favor and to allow the turnover of those additional funds that we believe might be missing based on the actions of Ms. Beasley and her attorney. And so that is in process. We are just waiting right now on a final ruling from the court. And once we get that, then we'll continue to move forward with that. What are the other sources of money to cover shortfalls to make people whole? Will the promoters of the scheme have to forfeit more assets to cover these shortfalls? So in these types of cases, typically we will go after people who either got profits or who got commissions for promoting the scheme. And in those cases, we generally will ask people to return those funds, and if not voluntarily return, then in most cases we will sue to get those funds back. Again, the goal in this case is to make everybody as equal as possible. So if you profited, those aren't real profits. There were never any legitimate investments in any of these personal injury settlements. So any profits that were paid out are false profits because there weren't any legitimate profit. So the money that you received as profit was actually money from another investor. And that is what makes, that is why that this is alleged by the SEC to be a Ponzi scheme, because people were getting paid out of other people's money. Last question, will the receiver file a lawsuit against more banks than just Wells Fargo? So I can tell you that the decision has not yet been made to sue a different financial institution, but I can tell you that they are in discussion and that there are a couple banks that we believe we may have a case against, but we are continuing to build that case as we go through the forensic accounting and figure out how much money went to these other parties and what happened while they had it, while the financial institution had it. And so it's likely we will see additional litigation against a couple other financial institutions. We won't mention them, and we're not going to say anything about them until we get closer to getting ready to file those cases, and then you'll see it come because we're going to request permission of the court to allow us to file it. Okay, so the next category of questions relates to the forensic accounting. So the question is, how much money has been recovered to date from each category: clawbacks, sale of assets, and bank settlements? So I actually did not bring the exact numbers with me for the call today, but these numbers are available in my report. The next report will be filed in the next 18 days, and at which point that information will be available to you. As you guys are aware, right now we have about $60 million in cash, just a hair under $60 million. And we are also still sitting on a handful of different real properties. We have cars still that we're in the process of selling, as well as some jewelry, gold, and some other things that we have been collecting over the last few weeks. We continue to collect assets and sell them as we're collecting them. You'll notice that a lot of orders have been going through the court to sell these various different properties. The good news is that the real estate market in Las Vegas appears to be pretty solid right now. Which was not the case as of a few months ago. And so we are starting to, continuing to see really good values on these properties that we're selling. In fact, most of the properties that we've sold, I think with maybe the exception of one or two, we've actually sold for a profit over what was paid for them. And so that's good news, because of course that then continues to add to the pot of money that's available to pay investors. Question 2, could you make a list or a spreadsheet of just the money that has been collected in the source, and then a list of expected income and from what source? So we actually, as part of our report on the amount of money that we've collected in the various different categories, as well as we do list some very speculative numbers related to what we think the assets that we're going to continue to recover are. Of course, they are, speculative at this point. For example, Wells Fargo, like I said, we believe it's probably in excess of $100 million, but it could be more, it could be more than that. It could be twice that. It could be 3 times that. We don't know yet because we don't have that final number yet. But as we continue to push towards it, we will continue to refine those numbers and continue to report on them on a quarterly basis. You'll see in our reports, not only do we list where the money comes from, but we also list every penny that's being spent. Because as you might understand, when you take a piece of real property, you have to insure it, you have to, maintain the property, you got to pay the HOAs, and then, property taxes, and then we sell them. So there is some cost to the sales and the acquisition of those properties, but, it's very, very minimal compared to the amounts that we're selling these properties for. Do we know how much real money went into the Ponzi scheme? As of right now, we know that number is in excess of $490 million. We believe that it's actually going to continue to grow because we've seen money going into other accounts that we did not know was the original source of funds. And so that number will continue to grow. We do anticipate it will, exceed 500 million by, some number. I don't think we're going to see, 550 or 600 million, but I do think that we're going to see it in excess of 500 million and potentially higher. Let's see. The forensic has the forensic accounting analysis been complete? If not, how close is this to being done? So the forensic accounting analysis has not been complete, for all the reasons that we stated below. The amount of time it's taken us to get documents, and the number of transactions, the number of accounts, and the lack of an underlying accounting. So when, as I mentioned, as we look at these transactions, we have to figure out what they are. A lot of them are payments to and from investors. but a lot of this money went through other business accounts, legitimate businesses that are operating businesses. And so, we have to pick out which ones are business related expenses versus our expenses or income related to the J&J case itself. We will continue to work on that and continue to push towards it. Like I said, our hope is that we'll have an initial high level understanding of the full dollars in and out, by the end of this year. And then we'll continue to work that towards solidifying the numbers for investors right after the first of the year, with the hope of wrapping that up as quickly as possible so we can begin the claims process. Let's see, what is the initial gross amount lost? That number is actually unknown from our perspective. The SEC has produced a number in their information, but that was also based on incomplete information. So we think that that net number between how much came in and how much went out, is going to continue to be refined over the next few months. But we do believe that the gross amount in, like I said, is right now just under $500 million. Let's see. How close are you with your forensic accounting to allow investors to show their believed loss? This goes back to the part again about we don't want investors to have to, provide all the documentation, because ultimately what would end up happening is every investor would have to send us, somewhere between dozens and hundreds of pages of documents. And we don't want to have to do that because A, it's expensive to review those, and B, it's expensive for you to get them and for you to send them to us. So we're trying to do it in a much simpler way that, accomplishes multiple goals all at the same time. So our hope is to be able to begin the claims process in the early part of 2024 with the goal, if everything works out well, with the goal of doing a distribution sometime in 2024. Let's see, to this point, how much has been recovered? As I said, there's over $60 million, or about $60 million in cash, plus, multiple other assets that are still in the process of being sold. I do believe, that the net number, the net number is up over $80 million at this point, working towards $100 million. We did just sell we just got permission to sell 2 additional properties this week, which should bring about $3 million to the estate. We have another deal that's closing next week that should bring another $3 million into the estate. And so, each one of these deals that we're working on doing and collecting are bringing millions of dollars into the estate, and that all gets added to the pot. How much money will it take to make everyone whole, assuming all clawbacks are received? That's not a number that we know yet, because we don't know what the difference is between the gross amount that came in and how much went back out. But the goal is always to get as much money back as possible and to repay investors, as much as possible. We don't put a cap on the number. In these cases, it's rare to get back 100% of people's money. We would love to do it, but there's obviously no guarantee that can happen, and some things definitely have to go our way. And we have to get some sympathetic people involved, but the goal being that we're going to get back as much of it as possible. At the end of the day, that's what we know make investors happy, is to get their money back, and B, that's also how we're judged on the work we do, is by how much money we can get back into the hands of investors. And we understand that this is people's investment, that a lot of this is people's retirement money, and we take that very seriously. We focus really hard on maximizing recovery through the assets we collect. We watch the money that we're spending and how we're spending it to try to make sure that it provides a benefit to the estate. And, we ask that professionals who are involved in the case take discounts, and that any money that isn't, that didn't benefit the estate, any billing that didn't benefit the estate get written off and not charged. And so we're very serious about that, because we do believe that it is very important, in these cases. So how long do you think this investigation will last? It's impossible to say from beginning to end. As it is that we will continue to work towards that. Work towards getting it wrapped up as quickly as possible. The forensic accounting is really the key piece of the investigation, as well as some of the background work that we've done, and continue to work towards towards figuring out every penny that went in and out. Last one is, please explain the 1,417 unique investor entities and 236 separate financial accounts. So 1,417 is the number of investors that we have on our list of investors currently. That number does continue to climb on a almost daily basis, and will continue, up and through the claims process. The 236 separate financial accounts, those were the number of accounts that we had at the time we produced that number. that we had reviewed or in the process of reviewing for the forensic accounting. Those are the financial accounts that got money either in or out of them related to investment funds. Clawbacks. Since this is a Ponzi scheme, will the receiver seek to recover funds paid to all investors? So typically a receiver will seek to recover any profits that were made, any false profits that were made, and that will likely be the same in this case. Ultimately, that is up to the judge on what does or does not, that we are or are not allowed to go after. But typically, we will go after the profits and then also commissions that were paid to promoters of the scheme. What is the status of IRS clawbacks? It is in process. We have hired a tax accounting team who have experience in doing that, and we're in the process of getting that clawed back from the IRS. We're restating the tax returns, and we'll be getting those refunds processed. The status of the Nevada bar clawbacks, that will wrap up as we wrap up the forensic accounting. Again, we need to have a solid number to go to the bar with that shows how much money was paid to them of investor funds versus client funds. That's the same for the LDS church clawbacks. We've been in communication with them. They've already agreed to return funds. We just have to provide them with the proof of what we think those funds are, and then we will begin to work through the process of them returning those funds. Will the receiver pursue clawbacks of net winners? That goes to the same question that was above. Yes, we will seek to recover funds, or we're likely to seek to recover funds from net winners, again, because those were false profits. Have you started the clawback proceedings? And if not, will you do that and go after the funds collected by net winners to return to net losers? The answer is yes. And that will begin as part of the once the forensic accounting wraps up and we know exactly how much people got, then those letters will begin to go out and the litigation will begin to get filed. Somebody asked what the definition of a clawback is. A clawback is simply going after funds that were returned to an investor that was over and above the amount of money that they had invested into the case, regardless of promised profits or interest or anything like that. Because the interest was fictitious and the profits were fictitious, we ask that those people return those funds in order to try to make some investors who did not give their money back whole. Next question has to do with the claims process. First question is, I was never given an actual contract, and the person I gave my money to has never been named in any of the documents. Does this exclude me from claiming funds? No. So the person that you invested with does not have to be named as a defendant. In fact, there are dozens, if not hundreds, of promoters who are not named defendants in the case. And so when the claims process begins, we will have a list then of all the investors involved and how much we think they invested in the case. And so we will begin the process by most likely sending letters to those people saying, here's what we think your claim is. To the extent that you aren't identified as an investor, it does not prohibit you from filing a claim. But when you file a claim, we may ask that you submit documents in that case if we don't know who you are or we haven't seen your deposit. So then we can trace that down and figure out where that money went and how it was being used. Why is there not a priority to send money to those who invested last or put larger sums of money in? There is no advantage to being the last in or the first in. In fact, all investors are treated equally from the perspective of how the claims process will begin. Typically, they are a money in, money out process. If you put in $100,000, you got $20,000 back, you're going to have a claim for $80,000. And that's typically how these types of cases work. And that's going to be true across the board, whether you've been invested for a month or if you've been invested for a year. In fact, oftentimes we hear that question the opposite way. I invested 5 years ago. Why don't I have a priority since I had my money in longer? Again, because the scheme, the underlying investment was fictitious, there is no difference between who went in first, who went in last, because there was never any profits to be paid or interest to be earned. How would we submit a claim to recuperate funds in the events that there are funds dispersed? So we will begin a claims process at the end of once the forensic accounting is wrapped up. It will be it will get publicized both through the pleadings that we file with the court. We will post it on the website. We will send out emails to everybody we know. We will publish notifications in journals across the country. So typically we would publish something in the Las Vegas Review Journal, being that's where it's from, probably the Salt Lake City Tribune, and oftentimes Washington Post, New York Times, Wall Street Journal, something along those lines, to try to make sure that we can catch as many investors as possible in this process. Let's see. For those that got zero return, will they be able to recuperate a bigger percentage than those who received returns? Again, it's done on a money in, money out basis. So it is based on your total loss, and then you will receive a pro rata distribution according to that loss. How much more does the receivership need to recover, or forensic accounting need to be done before initiating claims process? So we need to wrap up that first level of the claims, of the forensic accounting, and then begin to look at the investor side of it. Once the investor side of it is finished, then the claims process will start right after that. Is there any way legally that I can assign a beneficiary to the funds that I may or may not have received in this fund in the future? Yes, there are ways to do that, as well as if somebody's passed away and their estate is now the claim holder, that can also be done. The only thing I would say is be leery of who it has been assigned to, as it's ultimately up to the court as to what parties can have their claims assigned and to who they can be assigned to. So if you have questions about that, I would definitely talk to an attorney to make sure you understand what that process looks like, to ensure that gets done properly. Next group of questions relates to the distribution process. You mentioned that a partial reimbursement payment might be issued to investors in 2023. What is the status of that? Distribution cannot be done to investors until we know exactly how much each investor is owed, because the distribution will be done on a pro rata basis. So we have to know the total amount owed to every investor before we can pay any investor back. And so once that happens, then, like I said, once the forensic accounting finishes, then the claims process will start. That is a 90-day process, plus usually some 30 to 45 days after, to ensure that all auditing and recommendations to the court, and then to get the court to rule on the claims motion. And then the distribution motion will be immediately after that, where we ask the court to allow us to distribute, distribute the funds out to investors that are available for distribution. What amount of the recovery in dollars will activate at distribution? Generally speaking, we just wanted the number to be sizable enough to justify the cost of doing a distribution. The cost is pretty minimal to do them, but we want to make sure it's sizable enough to where we're not writing people a check for $1. So we want to get that pulled up. Right now, we have plenty of money to where we could easily do a first distribution. So as soon as the claims process is approved and the distribution process is approved, we will do a first distribution. And we will distribute out, all the money that we can, minus any holdbacks, for taxes and stuff, and other similar stuff. What are the other variables that will activate a distribution? So, large settlements oftentimes will, or just the sale of a large number of assets grouped together. Again, we just got to get to a minimum threshold that when we look at the distribution, it's sizable enough to have gone through the process of doing it. Usually in these cases, it's not uncommon to have 3 distributions, and in some cases 4 or 5 is not uncommon. So there will be multiple distributions as we go through the process. When will we get our return now that $100 million has been recovered? The gross number is less than $100 million. The net number is higher because some of these properties had loans on them. So the airplane had a loan on it, for example. But the first distribution will occur as soon as the claims process and distribution motion have been approved by the court. Literally, we can get a distribution done in less than a week. So that would be our goal from when the court can approve it. Regarding claims and distribution recoveries, if there are 2 investors, one that put in $1 million and received $900,000 in returns, and one that put in $100,000 but received 0, are they viewed the same in terms of what will be paid out and what is recovered? Because it is done on a money in, money out process, they would both have a $100,000 claim, because that is what their loss is currently. And then the funds that are paid out will be paid out on a pro rata basis on that $100,000. Now that assumes that the distribution is done in a typical pro rata fashion. In some cases, the courts look towards other ways of doing distribution, including what's called the waterfall distribution, which means that people have gotten nothing will get the first tier of the distribution, and then it flows down from there. But ultimately, no decision has been made on how that distribution process will be. and won't happen until we're closer to finishing up the claims process, because then we'll have a better idea of what the losses are and how were those losses sustained. Again, we are trying to do this in the way that is most fair to all investors. And so that's what we're always looking to figure out, is what is the most fair way to do this. And that's the way that we will recommend to the court. And then the court will ultimately make the decision on what they think is the best way to do that distribution. What is the process and plan with the funds which have been liquidated from sold assets? Those will be part of the distribution process. They will be dispersed as part of the distribution process. What is the probability of a 100% recovery? It's unknown. There are a lot of things that have to happen between now and then to get there. Number one, we got to figure out what the delta is on how much money is still owed to figure out what 100% means. If we look at what we've collected to date versus, the amount that came in, we're looking at 20%. But if we believe that, somewhere in the neighborhood of $200 million was given back to investors, and that money became, instead of 20%, all of a sudden becomes 60%. And so we have to really know what that final number is that's still owed to investors in order to know what the percentage of return will be. Plus, we have to, get favorable results in the litigation that we have against these third parties, because some of this money was spent in unrecoverable ways. Weddings, vacations, dinners out, things like that are typically, and gambling are typically not recoverable. So we have to look to other third-party avenues to recover those funds. And so we have to hope that we have a good opportunity to maximize the return there. How long after we file a claim will the distribution of funds happen? So as I said, the claims process is typically 90 days long. There will be another 30 to 90 days after that for the reconciliation approval process of that, and then the distribution. And then typically, like I said, the distribution will happen within a week of when it's approved by the court. What percentage of funds recovered will be distributed versus held back to cover ongoing costs? So as we get closer to the distribution, just before we file the distribution motion, we will look at what the outstanding issues are. We'll get advice from the tax accountants as to what, if any, tax liability exists. And then we will use that to figure out then what the amount to be distributed is. We're going to distribute out the maximum amount we can, while still ensuring that we can cover any costs that come out. The last thing we want to have to do is to send a letter out to every investor telling them they have to return money because the IRS is owed money, and so we have to recoup some of it in order to pay them back. We don't like to do that. That's not a very popular thing to do, and we don't want to have to do that. So we need to make sure that we can cover our costs that could be, applied to the receivership, but otherwise we want to distribute out as much as possible. Let's see. Can the disbursement be done on a percentage basis until the rest of the money is collected? Disbursement can be done, can and will be done most likely on a percentage basis. However, until we know exactly what people are owed, we can't distribute the money, because it could be that they aren't owed any, not every investor is going to be owed money. Some investors will have gotten their money back. And so we can't just pay money based on what people put in. Not to mention, we don't yet have a complete list of everything that everybody put in, because we continue to find investments that have gone through other accounts and went directly between investors in some other ways. So we don't even have that top number yet, let alone making sure that we're not giving money to people who've already gotten all their money back. Who are you waiting on to approve distribution? It will be the court that will approve the distribution once the claims process has been done. So, as we get the claims, once we begin the process, we'll take in the claims. We will work with investors to ensure they understand the processing and the handling of their claims. If for some reason we can't come to a resolution, then the dispute will go in front of the court, and the court will then decide on how to assess the claim. And then once that happens, the distribution process will be filed as part of it, and asking the court to allow us to distribute it. And once they sign that distribution motion, then the funds will go out. Let's see. What needs to happen to begin the distribution of funds? I think we've talked about that. Are we waiting for the outcome of the Wells Fargo litigation? The answer to that's no. We don't have to wait on the Wells Fargo litigation before we can make a first distribution. We just have to wait for the approval of the distribution plan, which requires the approval of the claims process, which requires the completion of the forensic accounting. What are the other variables that will activate distributions? Again, it's just got to be a large enough sum of money to justify sending out the payments. There's no advantage to us holding on to the money. The interest that we make goes directly back to you as investors. And so we like to get the money paid out as quickly as we can, because we want it in your hands. because, ultimately that's where it needs to go. So we don't hold on to money just to hold on to it. We hold on to it if we think that there's an exposure risk that we need to cover. And, we hold on to it until we have authorization from the court to pay it based on ensuring that we know exactly what everyone is owed. Let's see, how will funds be distributed back to investors? So that is a good question, because typically in a receivership, we would mail out checks to everyone. And that may or may not be the case here. We do know that there's been some significant fraud issues within the United States Postal Service. And so mailing checks, they've tried to discourage people from mailing checks. Assuming that that is still the case, at the time that we're preparing the distribution, we may look for alternative methods to distribute, including ACH or wire transfer payments. But that information will be determined as we get closer to the distribution time. Question about administration. How long do you expect the process of this receivership duties to go on for? This receivership will continue to go on for a few more years, but that is not to say that it's going at 100%. There are going to be times where things are happening where there isn't much to be done. If we're in the middle of litigation, for example, there might be months where we go by where there's only a little bit of work to be done, but we have to wait the outcome of it. So there will be some gaps here and there where things kind of speed up and slow down. And typically, once the claims and first distribution are done, the case will slow down significantly at that point as we go into the litigation phase and work through that. And then it will pick up again at the end as we're wrapping everything up and putting it away. And so you guys are aware, we're working on 5 cases that are similar to this. This is the largest of them, but they are all similar. And they all go through the same exact process. The timing, varies based on factors that are, outside of our control. For example, court hearings and those decisions, settlements with third parties. So the one thing that I would tell people to make this process go, quicker and less expensive is to assist us in, every way that you can. When we do the claims process, following the instructions and making sure that things are done that way, minimizing the number of duplicate claims, the amount of time that we have to spend working on these different things. That's why the forensic accounting is the key to this whole process, and making sure that that's right and that's done well, because that then will trigger the rest of everything that happens and ensure that it can be done quickly and inexpensively, because we will already have all the answers. We've done these types of cases where we end up doing a claims process in the middle of trying to finish a forensic accounting, and it never works well. It's always more expensive. It always takes more time, and it's just doesn't benefit anyone. So that's why we've asked for some patience, and we know that it's hard, but at the end of the day, it's going to be right, and it's going to cause the rest of the case to happen much quicker. And it may not seem like it, but this case is actually moving quicker than a lot of these cases typically do, because we've been able to get some of this litigation filed quickly, been able to recover as much money as we have, as quickly as we have. I mean, if you've watched the Bernie Madoff case happening, if you're talking about percentage of funds recovered, sometimes it's 5+ years before you see any sizable recoveries in this case. And we've been fortunate enough to go after and grab as many of these assets as possible, and that's made, possible in large part because a lot of the defendants who are involved in this case have been cooperative. I mentioned Beasley and Judd, others, Jaggers, Humphreys, and John Ward. Some of they've all been very, very cooperative with us. They've assisted us in getting information. They've assisted us in liquidating some of these third-party investments that they had. They've turned over assets, to the estate without, much of a fight. And that, has made that process go quicker and smoother. And that's why we have as many of the assets as we do right now, is because they have been so cooperative. Again, it's not my position to say if they're guilty or they're innocent, and their cooperation with me has nothing to do with that. From my perspective, is we're trying to get as much money back into the hands of investors as possible. The less fight we have, the easier that happens. And a lot of the defendants recognize that is the goal behind the receivership, and have been assisting us as much as possible to make that go quicker. That's not to say that all of them have been perfect and that all of them have been cooperative, but the vast majority of them have and do continue to be. And just because I haven't mentioned somebody's name does not mean that they have not been cooperative. I've just pulled out some of the bigger ones that we've been working with recently. And so I do want to point out that we have been seeing cooperation, even from Mr. Beasley, who's in prison. He's been cooperating from prison. Let's see, what other steps can investors take to help themselves in the recovery? The thing I would say is just be patient and be ready, because once the claims process starts, the earlier we can get claims filed in the process, the better it goes, because we'll begin auditing them as soon as we begin getting them. And so if everybody waits, if we get 1,000 people who file a claim on the last day of the claims process, that's going to take us, 30, 60, 90 days to review those claims. And so the earlier we can get them in the process, the quicker it'll go, following the instructions, making sure you're filing single claims where you should be, and not, filing multiple claims that we then have to deal with, so that's going to help that process out a lot. If you know of assets that you don't think we know about, reaching out to us, letting us know about it. If you think there are parties that are involved that we need to know about or have gotten money that we need to be aware of, please let us know. We have an email, we have a phone number, so I would encourage you when you run into that to go ahead and, to let us know as quickly as possible. Can you explain how your accountants are refiling previous year's tax returns to recoup the taxes paid? The tax returns are based on income. If the money that was claimed as income is actually proceeds of a crime, then those tax returns will get restated and the income number will be lowered, and therefore the tax liability will be reduced and will trigger a refund. And that's what we really have been working on. As far as the specific language goes, you'll need to talk to a tax preparer for that language. We cannot provide that for you. Fifth one here, my lawyers are dropping me as a client. How do I move forward? Again, the receivership is going after all the assets of the estate with the goal of recovering as much money as possible to distribute to investors. Investors do not have to be represented by counsel in order to file a claim. They don't have to be represented to take part in the distribution. The only thing, you just need to make sure that you're watching and listening, so when those things happen that you can get those in timely. If you choose to hire counsel, you're always welcome to. I would never tell somebody not to, but it is not likely necessary in order for you to participate in the claims or the distribution. Questions about the receivership and the receivership team. Why is the receiver using estate money to pay for fees and expenses? That's the only way we get paid. There isn't a pool of money somewhere to pay us to go out and do this work. So we go out and we do it on an hourly basis. We do use very reduced rates, as you'll probably see from the initial filing. We discount our rates significantly for the work we do related to receiverships and governmental entities. In addition to, we are constantly writing off time. Every quarter we write off time. We go through and we do a cost benefit analysis. If we don't think it's benefited the estate, we will write it off. But the money that we recover in the estate is the only money that's available to pay us. And if we weren't here, then investors would be responsible for going out and trying to collect the assets on their own. There would be litigation, as you guys probably saw before the SEC got involved. I think there were 3 bankruptcies filed, the state court receivership, and as well as a couple different bankruptcies, the bankruptcy, state court receivership, yeah. And so there were all these different things going on, and it causes a escalation in fees and costs. And even if this was a bankruptcy, the bankruptcy trustees get paid out of the assets of the estate. My job or my goal in this work, though, is of course to recover money that covers my own costs. So I'm out there looking to try to get back as much of it as possible in order to get back as much money in your pockets as possible. But the work that we do is critical for the recovery of these assets, and without it, there would be investors would be forced to fight with each other over what little was still available and around. Let's see, how much are the monthly fees for the receiver? We don't charge a monthly fee. We just charge based on the work that we're doing. And so that will vary from month to month, depending on what it is that needs to get done and who's doing it. Our rates vary across the scale, based on our experience and the work that we do. I can tell you that we are significantly cheaper than any law firm that you'll find out there. And our rates are super competitive in the marketplace. And, I'm not ashamed of the money that we've had to spend to do this work. I know that it stinks because it is investor money that we're spending, but again, we're spending it to recover more money. And, that old adage of you got to spend money to make money, it's especially true here where there's been fraud and there's so much money that was out there and in so many different people's hands. You need one person who can orchestrate, or one team who can orchestrate the recovery of that and the reimbursement back to investors. See, why are recoveries given to professionals before being sent out to the defrauded investors? The primary reason is we can't send money out to investors yet because we don't know how much all investors are owed. And as we get that figured out, we will then begin to do that. It would not be, I would have a very difficult time getting a team of professionals to come work for me if they knew they weren't going to get paid for the first 2 years. As most of us are small businesses, we do this at a discount. So we have to be able to seek permission of the court to pay, pay for our staff and our overhead and time. But again, I encourage you guys to look at the fee applications, look at the discounts that have been applied. And if you guys have questions about, what we're doing, please do reach out. We're always happy to talk about it. Let's see, if investors would like to file a complaint against the receiver, who would they contact? You can reach out to the judge. The judge is the ultimate one who oversees the work that's being done. In this case, our judge her name is Christina Silva. She is located in the U.S. District Court for the District of Nevada, which is located in Las Vegas. I think it's 333 South Las Vegas Boulevard. And you can get on the court's website and find her information. If you have questions, you can also reach out to the Securities and Exchange Commission. But of course, if you have an issue with me, I would encourage you to reach out to me and talk to me. I would love to talk to you about it or talk to one of my staff and see if we can't figure out what the issue is and how we might be able to help resolve that. But otherwise, those are your other avenues of contact. But I am available to investors. If you do have questions specifically, please do reach out. Last section here, it looks like it's on the next steps and communication. How many investors have you currently found? As you saw from that last graphic, it was last discussion was over 1,400. How do you contact us? The best way to contact us is via email or via telephone. The email is, and this is also available on the website. The email is contact@jjconsulting-receivership.com. That's contact@jjconsulting-receivership.com. And receivership is RECEIVERSHIP. Or you can reach out to us at 702-832-2299. That's 702-832-2299. The website is available. It's jjconsulting-receivership.com. You can go on there. We list all the documents, all the pertinent documents that have been filed in the court case, as well as our reports and other information. You're welcome to get on there and take a look. Otherwise, if you have not already done so, I encourage you to register on the website. Once you've registered, you'll begin getting monthly emails from us with updates, as well as court documents that have been filed by the court. You'll also make sure that you get notice of the claims and distribution process, which will all be posted there, and emails will go out as well. So, if you have questions, I encourage you to reach out, again, using either of those methods, and look forward to continuing to update you as things go forward. We're looking forward to this quarter really focusing on selling the assets that we're holding, and to begin to wrap up the claims process and focus then on getting those claims done, or I'm sorry, the forensic accounting process, so we can get the claims process started. That process will go fairly quickly once we get it, and look forward to continuing to answer any questions you might have and working with you guys on this case. Please feel free to reach out. Otherwise, thank you guys very much. I saw that in the chat that we had posted the phone number, the direct line to reach out and contact us. Let me just see if there's any questions in there that have not already been answered real quick to make sure that we're okay. One of the questions is about estimating the amount of return. At this point, we're not in a position to do so, but we're getting closer and closer to being able to do that as the forensic accounting we're getting more and more answers related to the forensic accounting. We will be posting a copy of this call on the website, so people who missed it can go back and look at it, or if you have questions, you can go back and review it yourself. Let's see here. I think looks like, why don't you have the accounting bookkeeping information that Jeff Judd had? Jeff Judd has provided us the information he had. It was informative, but not complete. And we have incorporated that information into our forensic accounting. I think that is all the questions that I saw on there that we have not already talked about. But again, if you have specific questions, please reach out. Thank you guys very much and appreciate your time.